Mr. Gilbert, clause number 25, DCCR 1009. You're charged with the third-degree felony offense of driving while intoxicated, third or more, from September 20th of 2024. The indictment alleges you were previously convicted of driving while intoxicated August 7th of 2007 in Dallas County, and then again November 21st of 2014 here in Jefferson County. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 5 years. You would be ordered to pay a $1,500 fine and follow all of the rules and conditions of probation, including that 10-day upfront time. Now, with regard to weekends, I'll make that decision when we come back for sentencing.
Yes, ma'am.
So I'll need to see, what your work schedule is and things like that. So I'm not going to allow that to be necessarily part of the agreement. That's just going to be up to me at sentencing. Do you understand?
Yes, ma'am.
All right. So I'm going to mark through that with everyone's permission. Mr. Smith, Mr.
Yes.
Crawford. Okay.
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gilbert is not competent?
There's not.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and then we'll come back later for sentencing. When you leave here today, you need to stop and talk to probation. She's sitting at that desk right behind you, okay?
All right.
All right, we'll see you back at sentencing. Thank you.
Thank you, Judge.
I just leave with that. Right.
So where's Bradford? We're doing something. Bradford's she didn't need Bradford, she needs Lewis. Oh, and is he here? And did y'all talk to Mr. Lewis already? Where is Marvin in the back?
Yes, ma'am.
Could you grab them for me, please? And this is on, is it Lazo or Murillo? Lazo. On Lazo, are y'all ready to announce?
Oh, yes, that one, I think the state paperwork already done.
Oh, okay, let's get Christian Lazo, please. Yes, it's here. Sorry. Good morning, ma'am.
Good morning,
We've
Judge.
got you running today.
Yes.
Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you.
You're welcome.
No, it's not real, anything. Give me credit, bro. We get it, Lazo.
And this is the only one you're down here on, correct?
Yes, ma'am.
Okay, we'll get this one taken care of and get you back. All right, sir, are you Christian Lazo?
¿Usted es el señor Cristian Lazo?
Yes. And will your client waive the formal reading of the indictment?
He does.
Mr. Lazo,
Señor.
in clause number 25,
25,
DCCR 1423, you're charged with the first-degree felony of aggravated robbery from May 25th of 2025. And how do you plead to that charge?
Culpable.
Guilty.
Are you pleading guilty freely and voluntarily?
Safe.
Yes.
And are you pleading guilty because you actually did what they charged you with?
Safe.
Yes.
I have here on this tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with your attorney, with the interpreter?
Yes.
Do you fully understand them?
¿Entiende el papeleo que le explicamos?
Sí.
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any
no
right
va a
to
poder
appeal.
tener una apelación en su caso.
Sí.
Yes.
Cap of 15 years means the judge can't go above 15 but can absolutely go up to it. It's like saying, I won't empty your bank account, but I might take most of it. Also, listen for the jury trial rights explanation, because that's the fork in the road. Judge sentencing versus jury deciding guilt and punishment.
And it looks like the agreement that you've reached is for a cap of 15 years in prison,
Es de no más de 15 años en la prisión.
which means that you're leaving your punishment up to me.
Decir que yo debo de hacer la decisión de su sentencia.
And as long as I give you 15 years or less,
Es que yo le dé 15 años o menos.
you're giving up that right to appeal. Do you
No va a
understand?
poder apelar. ¿Sí entiende?
Sí.
Yes.
You have an absolute right to have a
Tiene
jury
derecho.
come determine two things.
De tener un juicio y que vengan a determinar dos diferentes cosas.
The first would be to
La
determine
primera
if you're
sería-
guilty or not.
Que ellos determinen si es culpable o no.
And then you could leave your punishment up to that jury if
Y
they
lo
found
que
you guilty.
Jurado y lo encuentre culpable.
And if we go forward this way, you're waiving that right.
Pero si se
And is
maneja
that what
de
you
esta
want to
manera,
do?
dice, entonces no va a poder tener un jurado y yo soy la que debería pensar.
Sí.
¿Sí entiende?
Sí.
Yes.
Do you also understand if you're not a US
Que si no
citizen,
es ciudadano americano,
that a plea of guilty or no contest,
que
may
declararse
result in your
culpable o
deportation,
culpable puede resultar en una deportación,
exclusion from admission to the
sin volver a
country,
entrar al país,
or denial of naturalization under federal law?
negar que pueda recibir sus papeles.
Sí.
Yes.
State tenders number one,
No objection, Judge.
it's admitted. Is there any evidence that Mr. Lazo is not competent?
No, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily.
Declararlo culpablemente por su propio
Find
decisión.
that you're mentally competent and understand the nature and the consequences of that
Entiende
plea.
lo que está pasando.
Find sufficient evidence to
Y
find
que
you
se
guilty.
tiene evidencia de encontrarlo culpable.
However, I'm going to reset your case so the probation department can do a pre-sentence report.
Condicional vaya y algún reporte.
And that'll give you more information, give me more information about you and your case.
Sobre usted y su caso.
And then we'll come back later for
Luego,
sentencing.
Vamos a venir a sentencia.
Anything that you think is important for me to know,
Cualquier cosa que usted piense que es importante.
get that
que ella
information to
sepa,
Mr. Lewis,
pase la información
and he'll present it to me
a su
on your
abogado,
behalf when we come
y él me
back.
lo va a presentar cuando regresamos.
Okay, thank you very much.
Okay.
Thank you, Ms. Burge. And if you'll just real quick, I think probation is probably gonna hand him a piece of paper if you'll just make sure he
Yes,
does
ma'am.
it. Thank you.
Right here.
Is in the back. I'm not, I'm getting that.
Okay, thanks. Mr. Parker, you have Tristan Jones.
No, I talked to Luke about the gas, and he might, but he's gonna. He said, not gonna, it's a, he lived out of top passing, it's a situation.
Oh,
Who the person is, maybe man, but we.
remind me after this one, and I'll take a quick break and look at that up here.
Okay, thanks.
I've got one that's probably not here, but the prosecutor asked me to call my client, and I don't have a number for my client. Oh, yeah, they-
Judge, on this one, if we may, proceed on the full indictment, I think we need that to get to the third.
Good morning. Are you Tristan Jones?
Yes, ma'am.
Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Hold on, I've got too many things. All right, Mr. Jones, in clause number 25, GCCR 1668, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from September 30th of 2025. The indictment alleges you were previously convicted of evading arrest or detention October 18th of 2024. And then after that was final September 25th of 2025. And then the indictment further alleges that you were previously convicted of possession of methamphetamine, state jail felony, February 8th of 2018. And after that was final, you were convicted of unauthorized use of a vehicle, a state jail felony, February 26th of 2025. And how do you plead to that charge? So to the original charge of evading arrest or detention, from September 30th of last year, are you guilty or not guilty?
I'm not guilty.
Okay, so why did you do paperwork for a plea of guilty?
Oh, I thought, I didn't know you were adding all that together since 2018.
That's the stuff that we talked about, how you get to where you're a third degree felony. I explained it to you when we were in there.
I used all of that? A lot.
It is a lot.
I've explained the same at length, Judge.
So those prior offenses make it to where your punishment could be a third degree felony, which is between 2 years and up to 10 years. So the first two, the evadings, make it a state jail.
Yes,
So you've
ma'am.
got a misdemeanor that is enhanced to a state jail because you've got more evadings. Then you've got more state jails from prior, which makes it then a third degree felony. Do you understand?
Yes, ma'am.
And that's what Mr. Parker went over with you?
Yes, ma'am.
Okay, so to the offense of evading arrest or detention with previous convictions, are you guilty or not guilty?
Yes, ma'am.
Guilty or not guilty?
Guilty.
To the prior offenses of evading arrest or detention, are those true or not true? Is it true or not true that you were previously convicted of evading arrest or detention in 2 prior cases?
True.
And then is it true or not true that you committed the state jail felony offense of possession of methamphetamine in February of 2018? And then after that was final, you were convicted of unauthorized use of a vehicle of state jail in February of 2025. Are those true?
Yes, ma'am.
True or not true?
True.
So did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind later if I go along with this agreement. You understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objections?
it's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that your a plea of guilty freely and voluntarily, and also your pleas of true. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with prior convictions. Find those prior convictions true in the indictment. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows these were agreements, or this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yeah.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. A firearm is a legal term. You should read that admonishment to see what devices qualify as a firearm.
The firearm admonishment. After a felony judgment, possession can become a whole new charge, even if you just had it, or it wasn't loaded, or it's in the car. The judge is basically saying, read this like your freedom depends on it, because it might.
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, ma'am.
So the court is aware, but he did just probably county jail time on most of those misdemeanors out of Harris County. He has done one lesser TDC amount, but he's never done as much as before. That was.
Okay.
And your Honor, just for procedural measures, he has a case out of Orange County. I'm not sure if they have a hold on him, but he thinks there may have been a PR bond set. I'm not sure, but I was hoping that there's somehow we could check and so he doesn't go to TDC and then we can get him transferred to Orange. I don't know if it's something to do. Okay.
Yeah, I'm not.
I just thought I'd bring to
The
your-
jail,
okay.
I mean, if there's a hold from another county, maybe the best thing to do would be call Orange County to
Okay.
let them know that we're done. And
I'll
they
do
might, if they can come get them somehow, but if,
I'll do that, Judge.
that would probably be the best route, because if they don't have a hold on them, then our jail's not gonna see it
Okay.
and do anything with it.
Thank you,
You
Judge.
can go back with the bailiff. Thank you.
I already called it.
All right, you're Ava Musgrove? Yes, Sharon. And in clause number 25, DCCR 0048, Ms. Musgrove is charged with the first degree felony offense of murder. And that's from December 29th of 2024. And what that means, ma'am, and we've gone over this before, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Yes, Sharon.
And I have a plea bargain rejection that you've signed here today with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 30 years in prison, which means you would be leaving your punishment up to me. I could give you 30 years. I could give you less. It would depend on any information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand possible consequences if we go to trial and what your options are. And do you understand all of that?
Yes, Sharon.
And do you want to reject that offer and have your case set for trial?
Yes, Sharon.
All right, and so based on kind of some of this back and forth, is there any reason to believe anything would change with regard to that offer?
No.
So I want to make everyone, make sure everybody's clear that there will not be a plea, this plea agreement will not be accepted after today. So it's either trial or a plea to something different unless there's some new evidence that's discovered that you guys don't have for some reason at this point. Do you understand?
Yes, Sharon.
All right, and as far as you know, everything's, you have all the discovery and,
As far as I know.
okay,
Of all the
any,
discovery,
you're not
yes.
waiting on anything?
No, I don't know anything that's going on.
Okay, we'll get it set on the next available trial docket. You can go back with the bailiff. Okay. Mr. Rojas, you have Marco Gomez. So on Gomez, hold on, it's a plea?
It was going to be, but then the victim called last minute and changed it. Decided she didn't want that. So
Okay, so I can delete
You can
that
delete the paperwork.
registration. I didn't get the rest of it. I just got the registration.
yeah, you can do.
Good morning. Are you Marco Gomez? Speak up, please. And this is clause number 21-36-534. And Mr. Gomez is charged with sexual assault set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
Ready. Stay true.
All right, obviously, this is one of the oldest ones we've got, and so I would anticipate that it would be pretty high on the list, if not the top. Is there anything that you guys need me to know or we need to discuss before I number those cases today?
No,
All right, it looks like there was a previous rejection back in November. No changes or to that. That was for 15 years.
that was the offer we rejected, Judge. We had actually signed paperwork this morning for 8. After we signed it, I think the complaining witness called Mr. Smith and expressed that she did not want the 8-year offer. And so that was withdrawn. So
Okay.
we're here back at the trial docket.
All right, so then I'll set it. There won't be any plea agreements after today. Mr. Gomez, if you change your mind and want to enter a plea of guilty, it would be open to the court or to some other number other than that 15. Is that where y'all are at 15?
That's where we're at, Judge.
Okay, all right, then I'll set it and we'll probably see y'all at 1 o'clock on the 23rd. You can go back with the bailiff.
Judge, I have Willie Pugh.
Yeah.
Just need a reset on that. He's looking to hire in his own term.
Let's get Mr. Pugh, Willie Pugh. Willie Pugh.
Well. Thank you, Judge, for putting that detective in.
Yeah, no problem. All right, are you Willie Pugh?
Yes, ma'am.
And this is 25 DCCR 1835. Mr. Pugh's charged with unlawful possession of a firearm by felon. Mr. Pugh, Mr. Rojas has let me know that you or your family are trying to hire a lawyer. Is that correct?
Yeah.
So are you asking me to reset your case a little bit to let y'all do that?
Yes.
So what I'm gonna do is about a 30-day reset, which is a normal reset. If y'all get someone hired, they'll do the paperwork to substitute in. If for some reason you're unable to hire someone, Mr. Rojas is still your attorney, will remain on your case. And when we come back at that 30 days, if you haven't been able to get one, then we'll need to move forward with Mr. Rojas, okay?
Yes, ma'am.
All right, you can go back with the bailiff. Thank you, Mr. Rojas.
Thank you.
You've got Brian Trejo.
We've already taken
We
care of
already
it,
did that.
unless you want to reconsider.
Nope, I'm good. Thanks. Forgot.
When a judge tells you 5 to 99 years or life, that's not drama for the camera. That's the statutory range, meaning the court is reminding the defendant what trial risk really looks like. And that cap of 30 years offer, that's the prosecution basically saying, this is the ceiling if you plea. Trial could be way worse. Also, the judge drawing a line, this deal won't exist after today, is a pressure moment.
Oh, this Robert Lowe, we had him come back to do the registrations. I was wondering why that was here. Let me get those out of my queue to. I don't think so. We just needed him here, I think. Who was his attorney? So that's good. Let's see, Mr. Salinas on Carlos Rodriguez.
Hold that for 1 second, let me ask Ms. French.
Sure.
She's right outside. Yeah. At least she was 8 minutes ago.
Mr. Wilkerson, Mr. Vasquez. Okay.
You swear.
Let's see, Mr. Gertz, you have Giovanni Coleman.
I do, Judge.
Giovanni Coleman.
Right.
Did you hear how relaxed it is in here? Like, if you're in Harris County, I'm usually thinking usually in Harris County, it's like, you show up if you want, you don't, but it's weird. It's like, really? Guess because I've been nice on it, maybe. So far, anyway. Good morning, you're Giovanni Coleman, and this is 25 DCCR 0479. Mr. Coleman's charged with murder. Mr. Gertz, what is the announcement?
Judge, we're gonna ask for one additional resetting. There's a number of reports and videos in this case that involves, I would say, pretty hyper-technical cell phone and block evidence. So block evidence is photographic evidence. Okay, sorry.
Thank you.
Sorry. Is this your first day?
It's not,
my first day.
it's not my first day, but I appreciate that.
I apologize.
That's okay.
I'm so sorry. Either way, that a lot of the mapping and location and work that was done here just needs some additional review, in my opinion. And so, and then we were able to find very recently a ballistics report that was not labeled ballistics report. It was labeled like F-25 and didn't have any content. And so anyway.
So I'm gonna do one more. It looks like you have been on since May 2nd, so it's getting time for an announcement. I'll do another reset, but we need to see if we could get an announcement at that next court day. Okay.
Good. Thank you, Judge.
Stay in touch with, stay in touch. He'll stay in touch with you.
She'll tell me.
See, you've got me thrown off
Yeah.
now. Ronald.
Wait till this next case.
Ronald
And
Spites.
I need a couple minutes on that, Judge.
Okay.
I'm gonna be asking for more time on that, so if you want to call him out.
If, I mean, I can get it done if that's what you.
I can do that. I just need to talk to him too, so.
Spites. We can ask him to keep them for a second after. It's me. Good morning, sir. You're Ronald Spikes.
Yes, ma'am.
This is 25 DCCR 0920. Mr. Spites is charged with manslaughter, and Mr. Gertz, what's the announcement?
Judge, we're asking the court for one additional resetting on this. I need to sit down with him and just haven't had a chance to talk in detail enough about the allegations here and the evidence that they have provided us, which I believe have downloaded everything that has been uploaded. So,
Okay. anything that you know of that you're waiting on? All right, so Mr. Spites, what I'm going to do is, now that Mr. Gertz has everything, he'll be out there, I'm sure, to go over all of the information and discovery that he's received. And then we'll see where we are at the next court date. Okay, thank you. Ms. Holmes?
Yes.
You've got Tristan Calhoun, the sentencing. And thank you for taking care of Mr. Lowe.
Yes, ma'am.
Morning also. Good morning, sir. You're Tristan Calhoun?
Yes.
And Mr. Calhoun was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1216 and 1217. I've received the pre-sentence report as well as it looks like 2 memos from probation that were follow-ups to that report. Have you all had an opportunity to review all of that?
Yes, Your Honor.
I have, Judge.
Are there any additions or corrections to that pre-sentence report?
The only correction we had was, under the substance abuse history. I believe they, their alcohol data first usage, it should have been 18, 19 years old, not 8 or 9 years old.
Oh, okay.
Yes, ma'am, but that was the only correction.
Okay. Thank you. Anything?
Judge, I would just like the record to reflect that my office made multiple attempts via a regular victim contact letter with both of the complainants in these cases in order to try to obtain a restitution amount via that letter, via a restitution request form. I then was able to work with Miss Roach, who did some investigation on it. We have an investigator to find different numbers for those young ladies. They were able to reach out to them and have them call to the probation department as of this time, unless it's somewhere in the paper sphere. I don't have a restitution amount from them. I understand their concerns that they voiced, but I believe that the offer was appropriate based upon his lack of criminal history and the severity with which the court can punish him on any type of revocation. I don't know how Your Honor would feel about ISF based on his age, but I would suggest maybe at least considering the positive track of ISF.
And Your Honor, I have spoken with Mr. Calhoun in regards, I told him there could be restitution in the future if anything is provided.
Well, if it's not ordered today, there will not be any. And
Okay.
So that's why they attempt to get all that information. And it sounds like the district attorney's office and the probation office has made a diligent attempt to try to get any number. And so there's no coming back later for restitution. So we'll just have to go forward without that. Mr. Calhoun, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. And in cause number 25, DCCR 1216, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 7 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'll go over some of those in just a few minutes. And then in cause number 25, DCCR 1217, also find sufficient evidence to find you guilty. However, I'm going to follow that agreement and defer all proceedings and place you on probation for 7 years. You'll be ordered to pay a $500 fine in that case as well and to follow all of the rules and conditions of probation. I am going to order that you enter and successfully complete the JCDI program. It's an outpatient treatment program. That's what was recommended after that substance abuse assessment was done. I'm not going to order any further upfront or ISF. I think you're 28 or 29.
28.
Okay. This seems very, very out of character for you. And this was a terrible day, and what you did was terrible and affects at least one of these ladies had some significant issues and probably will forever based on this. But I mean, you have no criminal history, and so we're going to get you the help you need, and hopefully you can be successful on probation and not have any issues. So what that means is you don't have felony convictions on your record right now. And if you successfully complete these probations at the end, the case will be dismissed, both of them. You'll never have a felony conviction. So it's a great opportunity that you're getting today.
Yes.
The other side of that, and part of what Ms. Molfino was stating, is that if you violate any condition of your probation, you can be brought back into court. And then I could find you guilty of both of the offenses and sentence you to prison for between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
So I'm handing you in each of your cases, the trial court certifications that shows these were agreements that I followed. And so you have waived your right to appeal. Probation will talk to you before you leave the courtroom today. It's very important that the first thing you do when you are released is go to the probation office and make sure you get everything started and lined up with them.
Yes, ma'am.
All right, yes, ma'am.
Sorry, just if I may, so the
Safety.
record reflects and in the instance that anybody is observing. Of course, I would not hesitate at all to put those victims in contact with victims assistance for on victims compensation.
Yeah.
Based on these pleas, I think that would be an avenue that we can travel down, and that I don't want this to obstruct that, but I understand the restitution amount. I did not have support today.
Sure, and there are definitely some avenues, if they get in touch with the district attorney's office, that might could help them with some of that. Okay, thank you, Ms. Malfino. You can go back with the bailiff.
Thank you.
Yes.
Thank you.
All right, careful.